I'd like to spend a little bit of time over the course of the next 3/4 of an hour just taking you through what I've actually referred to as a slightly different title, which is the crash course, the compliance crash course in GDPR. And I suspect many of you will already have got a relatively good feel for this being a little bit of a mess, a little bit of a storm of activity, a dramatic change for the business, possibly something that you're looking at on a regular basis but pushing further and further away from you for a number of obvious reasons, I feel. The principal one being that it seems like even if it's not getting in the way of business as usual now, it is going to become increasingly more in the way of business as usual. And like a lot of compliance-based activities, we look upon those unfavourably when we think, well, if I've got to spend 10, 15, 20, 200 hours on something, it's not going to be that. So hopefully this will give you a quick and dirty insight into GDPR and how to make it a little bit easier. I'm going to take questions at the end if I've got enough time, and I'll also make available the slides through the IoD, so you're welcome to take those. There are only a couple of slides in there where there's a little bit of detail on them, and when I was preparing for today, I didn't make any apologies about some of the detail. Some of the detail on there is intentional because of the legal wording that is used in the regulation. Put your hand up if you've seen the regulation. Yeah, few people. So you'll have seen it. So it's over an inch thick. It's 99 articles. It's overall several hundred recitals, clauses, and contract subtext. It's a big document to work your way through, and even the idiot's guide to it isn't much better. It's largely an easier to access document because it's only A5, but it's only written in 8-point text, which is how they did it. So there are a few areas of this that are very wordy and driven by the legal speak behind it. So please feel free at the end to come back on any of those points. So there is a disclaimer. Now, inevitably, there's a disclaimer with anything that relates to legislation. This isn't legal advice. I'm not giving you legal advice. I'm going to give you opinion, my opinion, Purple's opinion on issues that have been set in the legal environment around GDPR. What that means is you do have to do a bit of due diligence yourself, and I think looking around the room, you'd all know that already anyway. But please do bear in mind, I'll be around for a short while afterwards if you have got other questions that you don't want to ask in front of anybody else because you think you might have a problematic area under the GDPR. I'm happy to give you my 2 pence and tell you what I think and tell you the extent to which you're going to be in legal trouble or not. Okay, so simple agenda. What is it? And I won't dwell on that for too long because I suspect a fair few of you already know that. Does it apply to us? And I'll give you the punchline there. Spoiler alert, it applies to everyone in the room. You've just got to get over that part. And then we'll talk a little bit about controllers and processors because there is some confusion when you read the legislation. It's quite lengthy around this issue of whether you're a controller or a processor. So I'll talk about that and I'll introduce something you may have missed, the concept of the joint controller, which makes it a little bit messier still. We'll talk a little bit about data protection officers. Some of you will have one already, some of you will be planning to get one, and others of you won't know whether you need one. There's a lot of confusion about that, and I'll take away some of that confusion and bust a couple of myths around that. Then we'll talk about sanctions and penalties, because that's the scary stuff that you'll already have an insight toward. But what I'll do is give you some signposting there as to the extent to which you really are facing a doomsday scenario. And the answer, again, spoiler alert, you're not. Finally, we've got a do now checklist at the end. If you do these 10 items over the course of the next 73 days or so, you'll be in good order. You really will. So take them away today. Have a look at those in the context of trying to squeeze them in and around regular business as usual, and trying just to get your head around some of these points. Okay, so that's what we're going to work through. This came about as a result of quite a lot of work that started back in 2012. We've actually had a 2-year implementation for this before we get to 25th of May, but most of you won't remember being written to. Who does their filings online, their annual return online? Yeah, quite a few of us, yeah. So apparently there was a letter came out in the post along with the annual return request back in 2016, and if you're like me, I ripped it in half and threw it in the bin because I file online. So the prospects of actually getting that heads up, that awareness, being made alert to what was coming around the corner, are pretty slim. And the problem is there really hasn't been a lot of people shouting about this other than to suggest that it's a doomsday scenario and to throw into the mix that you're going to get fined a huge amount and that all of this is insurmountable. And all of those wonderful myths just make it a little bit more newsworthy for people looking for something to write as probably a little bit of relief from reading and writing all about Brexit. And I suspect that's why. But it's going to kick in. It is the most significant change we'll have ever seen. And the reason for that is very simple. For those of you who remember the internet and e-commerce back in 1998, you'll remember we didn't have wonderful things like we have now in terms of the ability to click with one button on a mobile phone and buy something from Amazon that would randomly turn up the next morning outside your door. We didn't have that. We were dealing back then in 98 with an environment where the threats and vulnerabilities about information security and data breaches were literally driven by large-scale, big corporates processing truckloads of data in dark rooms, which were largely impenetrable. So the risks were much, much smaller than they really are now. So fast forward to where we are now, we've got a world where, on average, we see 7 to 10 breaches per week. And since December the 1st, we've had somewhere in the region of 200,000 global data breaches. Some of them small, some of them insignificant, some of them very large. Can I just ask for, again, a quick show of hands? Who's an Uber user? Good, we've got your data, thank you very much. So all 2.8 million records they have for UK users, that's 2.7 million customer records and about 100,000 driver records were breached last year. And of course you all heard about that, didn't you? Yeah, you all got told by Uber that they'd rinsed your data? No? Surely somebody did, no? Well, maybe this is why we've got something like this coming along. Because they're not the only ones. If you use Bupa, anyone a Bupa user? Bupa users? Yeah, good. 400,000 UK records last year, health records. Do you want people knowing your health data? No, I don't. I really don't want people knowing that stuff because I know that you can extract commercial gain from it, but you can also create tremendous embarrassment from it. Now, that's enough about my personal records. But we'll pick a couple of others. So there was a Moonpig breach, or rather it was a vulnerability that was identified with Moonpig. Who's a Moonpig user? Yeah. Now, again, the extent to which it was perpetrated was probably quite slim. There probably weren't many people losing data over that. But the vulnerability was identified with the Android phone platform. And as a result of that, there was talk on the dark web. Yes, I do occasionally hang around in the dark web. In the dark web, they were talking about the fact that that data had been lifted through the app and that they were able to reverse engineer it and discover lists of recipients of goods and products who were not the spouse or partner of the person who paid for them. I'm not sure why that would be newsworthy or otherwise, but I'll let you work it out. But therein lies the issue. We live in an environment now where actually this is relatively easy. You can go into the dark web. You can use a browser that you can download for free. I'll give you the name of it. I'm not going to hide it. It's called Tor Onion. Now, all I will say is that whilst it's untraceable, you go into Tor Onion, it's totally untraceable. There is every possibility that every time somebody downloads that, you're sending a flag up somewhere in probably GCHQ's computer systems and various other people's, because why are you using a 100% anonymous browser unless you're trying to hide something? But you can go on there, you can see this, and you can see things such as 25,000 live credit card details, live UK credit card details, available for around about 50 units, which is around about 6 or 7 Bitcoin, or I don't know, a couple of £100. That easy. And that's because people have been less than great with the data over the course of the last few years. Hence this. So this has come about. This is designed to strengthen and give life to some real data subject rights. And whilst you're all sitting here, you've got your own businesses, you're also data subjects. And you should feel enough passionate about this from a user perspective. You don't want your data rinsed, but why should your customers have their data rinsed? So there is a need to do something. The only problem I have with all of this is there is a lot to do. And unfortunately, that work needs to be done whether you're a large multinational, whether you're a small business. So does it apply? Yes. It will apply to you if your customers are EU citizens or if you collect data from EU citizens. The good news is it applies to anyone anywhere in the world for whom those statements are true. US business, Canadian business, Australian business, if they deal with EU citizens, it applies to them as well. They haven't really woken up to this. That's the really interesting point with this. And some of them are the most toxic organisations. Certain large UK enterprises where they've moved their contact centres to the Philippines and Chile and places like that, where they're regarded as slightly toxic locations to move data to. So there are real challenges around all of this. If you're an overseas business and you're trying to do business with an EU citizen, you're required to put or appoint an EU representative to manage and wrangle your relationship with data subjects within the EU. How many organisations from overseas do you think have done that? It's purported to be less than 2% at the moment. So a lot of these guys are late to the game. That's good news. Good news for you. It's good news for all of us, to an extent, because what it means is that come 25th of May, the people who are most likely to be in trouble here are the people who are already doing bad things with our data from an overseas environment, where they will probably attract the attention of the ICO. Now, just a point on the ICO. The ICO is the supervisory authority in the UK. It's run by Elizabeth Denham. She's not English. She's Canadian. And I suspect that's why the ICO is actually a really functional organisation. It's an incredibly functional organisation. These guys are your best ally. They will help you. They don't want to cash you out. They don't want to set bear traps. They are there to help. What that means is that you can ring them up, you can get data off their website. They have written very informative blog articles. And even if you suffer a massive breach later on and you don't really know what to do, you can ring them up and they will still continue to help you. We'll talk more about that later on because it's quite a key point. Okay, so in terms of the coverage, it covers personal data, in the main, personal data. But it covers special category data, which under the Data Protection Act was referred to as sensitive data. And there's some expansions here that start to make this a little bit more tricky. Personal data and special category data set out on here. Now, I apologise, some of the text on here is small. As I say, the slide will be available. But usernames, names, addresses, any other location or tracking data, even GPS data, if it can be used to attribute something to you as a natural person or data subject, is regarded as personal data. Look at some of the others on here. Who collects cookies on their website? Who knows whether they collect cookies on their website? You know, if you're a Google Analytics user, yep, you collect cookies. And most people will have Google Analytics sitting somewhere within the enterprise. IP addresses. Never before have we regarded IP addresses as personal data. But your IP address now, so if you're capturing that and you're capturing what computer people are using or what mobile phone device, pseudonymized data, this is a wonderful term. By the way, I don't apologize for this. This is a bit of jargon, but it comes in with the law. The GDPR uses this term, pseudonymized data. That's pseudo-anonymized data. So I take your name, I scramble it so humans can't read it, but the computer still knows who you are. So it's pseudonymized data. That's regarded as personal data. So your hashed name can still be regarded as personal data if it's breached or leaked. Special categories, genetic data, biometric data, race and ethnicity, politics, religion, trade union membership, all of these wonderful things. Now again, you might choose to put some of that into the public domain yourself, but that doesn't mean somebody else can come along and pick that up and take it away and use it either against you or in some way, shape or form to extract value from you. Just a point on some of these. So CCTV, who's got CCTV at work? Yeah, okay, so that's caught. So you need privacy notices for your CCTV system. It's not difficult, it is pretty basic. You've just got to think common sense. You write something that says we're capturing this for the benefit of avoiding or detecting crime and criminal activities, fraud, etc., etc. But then you've got to give rise to the rights that the data subjects have under the GDPR. We'll talk about those shortly, but you have to signpost those to users. And a lot of this is good common sense about signposting. But actually, photographs, staff photos, anything where there's photographic ID in play, that's captured. And a lot of people capture either passport photo for, I don't know, anti-money laundering, KYC, or possibly alongside a work permit to see if someone's got a right to work in this country. And all of that data, which you might then stick in a file and never ever go back to again, you're going to have to be able to find that, and you're going to have to be able to disclose it. So we'll talk a bit more about that as we go through as well. So there's a lot of new, or a lot, big broad extension to what's personal data now, and these special categories. By the way, I'm deliberately, because I'm rattling through this, I'm deliberately avoiding some of the more contentious areas related to children and minors and people with special needs, where there are again some extended rights around those and some certain conditions you need to put into place. We'll talk about those later on in terms of what needs to be done. But if you are in a position where you capture children's data at the moment, maybe permission through the parent, you need to think carefully about how you secure it, how you audit it, how you actually test you have got a legal basis to have access to it. Okay, so does it apply to us? Yes, it looks like it does. So what now? You've got these key privacy principles, and unfortunately you have to comply with all of those key privacy principles. You also have to satisfy one of the processing conditions, and there are 6 processing conditions for regular personal data, and there are more for sensitive data. So if we look at the key principles, it's got to be lawful, fair, and transparent. Gone are the days now where you can essentially imply consent for sharing data. You know, you came on our website, you bought something from us, therefore buried away in the terms of business was a statement that said we could take every last piece of tracking data, name, address, and everything else, rinse, repeat, sell to our best mate down the pub or the rugby club or wherever else, and then do it all over again as we start to build up a profile about you. So lawful, fair, and transparent. It needs to be something which is limited in purpose. It needs to be basically predicated on how you will use it, and how you use it. You can't sit there and draft a statement that says, I'm going to use it this much. It must be particular and peculiar to your business, to what you do with your data. Minimizing data. So you have to minimize the data collection. Key thing here is, in the GDPR, they use this tenet that is referred to as data minimization. And data minimization is critical. It's all about saying, if you don't need it, why have you got it? Frankly, if you want to protect yourself, find all those archive boxes full of paper and get rid. Otherwise known as the Arthur Andersen shredding strategy. You might remember that, some of you might remember that. But actually, it's not too bad an idea, because if you've got it in a CRM system or in your sales system over here, or you've got it elsewhere in another database, and you're maintaining 10, 15, 20-year-old paper copies, why? Minimize the data. If you don't need it, don't store it, don't use it. Any recruiters in the room? No. So recruiters often talk about the fact they think they need the data going back to the year dot. How many people here would consider their own CV as being something that is pretty static from, say, 3 years ago, 6 years ago? It's not really, is it? The only thing that should be static is probably your name, address, and your early career history. Everything else moves. Your interests, your hobbies, where you are, where you live, what you do, your skills, experience, competencies. And you look at that and say, well, okay, if you're a recruiter then, maybe what you ought to be doing is minimizing your data. 6 months after you no longer need the CV, get rid of the CV, but keep the contact details. But then, under the GDPR, you can only really keep it for as long as is reasonable. And the problem with reasonableness, any lawyers? Yeah, you'll know what that means. When you get to court, it gets tested in court. And the way the courts work is they apply that man on the Clapham omnibus rule, which is what does he think is reasonable? I mean, I might think it's reasonable to keep it forever. You might think it's reasonable to keep it for half of forever. But if the average Joe down in Clapham thinks, you know what, 3 years sounds about right, and you're keeping it for 10, you might find yourself in trouble. Okay, let's pick a couple of others on here. So then over on this side here, conditions for personal data. You've got to have consent, or it's got to be necessary for the performance of a contract, or necessary for compliance with a legal obligation. Now those top three, to the main extent, will be the ones that will apply to the people in the room today. The interesting thing here is, you look at this and say, well, if you've got consent, you should be golden. So maybe consent is the gold standard here. Maybe consent, even if we are going to get legal, we're going to be preparing a contract, we've entered into a contract, maybe we should still solicit consent. Because actually that's quite easy when you think about it. When you engage someone, actually being upfront and saying, I'm going to do this with your data. This is what I'm asking for, this is how I'm going to store it, this is what I'm going to do with it, secure it, utilize it, give it to a third party somewhere else. Because then it makes the others easy to comply with, or at least then if you've got the belt and braces of you've entered into a contract, you're in a strong position. But think about your workforce. They're under an employment contract. When they write to you, send their CV, that's already regarded as explicit consent. I'm sending my CV to you. How much more consent do you need? But you've got to record it. Write it down. The date and time when that consent was given. Because later on, you may get asked to prove that you've still got consent and that it hasn't been withdrawn. So you need things like a consent register. But keep it common sense. If you've got a CRM, it becomes another field in the CRM. If you've got an HR database, it becomes another field in the HR database. But remember, enter into a contract with them, you're allowed to maintain that data. Even if they intend to, or are potentially, on the balance of probability, going to enter into a contract, then this second point up here will apply. The three at the bottom are more likely for other types of organisation. As I say, I know I'm rattling through these, but these will be available afterwards. So conditions for sensitive data. This is a bit more tricky. So you can pick, basically you need to pick any one of these. You need to comply with a minimum of one of these. And typically you'll find that so if we pick one here, necessary to protect the vital interest when consent is not possible. So if someone was in a coma, a child was in a coma, then you could avoid consent. You comply with this rule. But remember, with all of these things, if you are processing sensitive data, special category data, then you need to be able to think about what it would be like if challenged. What if the ICO comes knocking? What if I end up in court? What's going to happen then? Okay. So controllers and processors. A controller is a person who originates that original data set, and they work out what needs to be collected, what they're going to use it for, typically the reasons why. A processor might be a third party or someone you work with in partnership, or another organisation who is going to process data on your behalf. Any cloud systems users? Yeah, few. So they typically fall under the category of data processors. Under the GDPR, it's important that you write to these guys and find out what they're doing to comply with GDPR. Because you have to be able to show that you've done the right degree of due diligence to hold yourself harmless. So having a standard questionnaire that you can fire off to these guys and get it back and make a risk-based judgment becomes quite key. Because you might fall foul for non-compliance because you didn't ask your suppliers and processors what they were up to. And then joint controllers, where two organisations jointly control that data. And you can see that in certain environments where you may be working with somebody in partnership where you built your own data set, and that classic Venn diagram, the bit in the middle is the bit you jointly control. Then they also add a bit on their side of the arrangement. And by the time you're done, you're both controllers. Now, just so you fully understand this, with GDPR, the liability is joint and several. If you hadn't picked up that little gem, that's the one you need to worry about. Because if you outsource it to a processor who is toxic, and they rinse the data and there's a problem, there's a breach, or there's a non-compliance fine issued, an administrative fine has been issued by the ICO, that can potentially join you in. And whilst you can get insurance for this, the first question they'll ask is, did you have a process? The second question they'll ask is, did you follow it? And if the answer to either of those questions is no, good luck getting them to pay out on that insurance. Okay. So in terms of controllers and processes, there's a set of key requirements. The data controllers are required to conduct DPIAs. So if you control data, a data protection impact assessment, sometimes referred to as a data privacy impact assessment, and sometimes just referred to as a risk assessment. But that's basically saying, what data are we capturing? What risk does it pose? What do we need to be doing with it? How do we store it, secure it? And how do we make it available if somebody challenges us? You also now have increased consent requirements. The onus is on you to prove that you do have consent where you think you've got consent, and it needs to be explicit. Wherever possible, it needs to be explicit. In other words, none of this, you've bought something on our website, by the way, we think that gives us consent to keep your data. Be upfront. There's a real advantage from being upfront and open about this and saying to people, it's a differentiator. You know, we take your data privacy seriously. So you come on our site, you share data with us. This is what we're going to do with it. Here's the privacy notice. And by the way, tick this box at the bottom and we will record your consent, and you can withdraw that at any time, any stage in the future. It's entirely up to you. I'm only going to pick a couple of more out on here. So we come to the bottom then. We've got data processors must now keep written records. So the people you outsource your data to process on your behalf, they have to keep written records that essentially shows that they're doing the right things and they've shared those processing activities with you so that you're able to go back to your subjects, your data subjects, and tell them what's happening with it. Now, again, I don't know if you've tried speaking to any data processors. They're a little bit difficult at the moment. If you haven't yet, has anybody had a third-party questionnaire in? No. So does anybody work as a supplier for, let's say, Sainsbury's? Okay, Sainsbury's, okay, you probably get it eventually, 533-line questionnaire. Good luck. Yeah, I mean, it's basically, it's any of these organisations, UK PLC, British Telecom, anyone like that, they're going to have a hefty document because they want to hold themselves harmless. If you're doing anything on their behalf, they want to know that they can come back and blame you when it all goes horribly wrong. So you need to pass that through your supply chain. And you need to ensure that you're doing it to the extent that you fully understand where the risks are so that you could do something about it. I'm going to talk about top right in a moment. Data controllers need to respect the 8 rights of the users. And I'm going to talk about the bottom left. The GDPR makes privacy by design a core, fundamental, mandatory requirement. So the rights of the users, what do you have? Well, you have a right to be informed about the processing activities. It's a fundamental right. So you've now got to tell me what you're doing with the data, how you're going to process it. You have a right to have access to that data. You have a right to rectify it where it's wrong. Has anybody ever had a wrangle with one of the credit search agencies? Yeah, a couple of nods. Well, you have to write to them, and they don't correct the record. What they do is they put a letter on the opposite side of the file to the record. So all it says is, these guys said you were rubbish, and this letter says you're not really rubbish. So it's now up to the person looking at that credit file to say, who do I believe? Who do I trust? So you have a right to rectify that. You have a right to make data portable. Think about this. This is can I be rude? This is a ball ache. This is a real ball ache. Because that needs to be portable to the extent that it can be imported into somebody else's system. So that's exporting data from your CRM, your customer database in any way, shape or form, your order processing system, in a format that can be read by another system. But it also needs to be human readable. So you have to double up on the effort. Bottom left, the right to erasure, not the 1980s pop group that I remember very well, but the right to be forgotten, to have that data removed, properly eradicated in every way, shape or form. That's a real challenge. Think about it. If you're an organisation where you've taken regular backups, you get a tick in the box for being very diligent about your data enterprise. However, if what you're doing is storing that on optical disk, and that's gone off in an archive box somewhere, how do you erase a record on an optical read-only disk? So you've got to be able to do that. Now, most systems actually mandate that you then bring that back in as the live system, delete the record, and then re-archive that. So by the time you're done, you could have a bit of a mess in there. So just think on about your processes for backing up data and whether maybe now's the time to look at whether cloud backups might be a better solution where you can go in and remove individual records. You have a right to restrict or block data processing. Yeah, I particularly like this one. This is this one that says, oh no, you know, I still want to do business with you, but you can't process my data. That's going to be fun and games for a lot of those large organizations who have lived almost entirely and exclusively making money off the back of data and data transfers. You have a right to object to the data being processed. No, don't want that process anymore. Now think about this. This could be staff coming to you objecting to certain pieces of information they may have shared with you in the recruitment process that they no longer want you to be able to store or process. And we see that we've already started to see some of this. And then finally over here, the right to be protected from automated profiling. Now the problem with this is quite broad, this last one. Because if you do anything on your website where you construct pages on the fly from a content management system, where it is driven by the customer journey and the customer choosing to go one way or another, that's automated processing. So you need to signpost that you're going to do that and why you're going to do that. And then hopefully they'll still stick with it because they realise there's a net benefit to them in it. But other automated profiling, if you're an insurer, that could kick in at the point at which you're an insurance broker. That could kick in when you're starting to tier in additional on-sell, cross-sell, upsell of other insurance products. Okay, so privacy by design. This is what it's all about. This is not about retrofitting privacy to what you've got. That's privacy by default. This is about privacy by design, which means whenever you start a project, a venture, a new business extension, and what you're thinking about is the data you might need to make that happen, to make that successful, what you do is you start to apply these principles. So from day one, you're thinking about the risks you potentially expose that stakeholder to and how best you can put in place mechanisms to protect against the risks. The good news is, everything I've been through up until now, if you give people privacy notices, if you set out what their rights are, if you tell people you're doing privacy by design and you show them you understand what privacy by design is, if the ICO, heaven forbid, ever does come knocking on your door, you're going to be in a very strong position. Because you may still get a breach, you may still have an issue, you may still have an area where you haven't quite got it right, but you're going to put yourself in a much stronger position if you're able to say, look, I'm doing the right things, I've entered into the spirit of this, knowing that this is a journey, it's not a one-off, it's not like Y2K, not like Brexit. We've got a lot of knowns in here, and if we can head towards these, it puts you in a very strong position. Okay, but remember here, controllers. Controllers are companies that collect the data, processors are people that store it, manage it, and process it on your behalf. Joint controllers have to, by law, act in a transparent, open manner where they understand that their respective responsibilities are genuinely shared and that if there is an issue of non-compliance, you could be joined in on that. So it's up to you to make sure you can hold yourself harmless insofar as you ever can. Okay, so sanctions and penalties. What do you all understand about the fines? You all know the fine, don't you? Yeah, big fine. Yeah, 4% global revenues or 20 million euros. Yeah, it's quite hefty, isn't it? It's hefty. Now, what a lot of people don't realise about the fines is the fines, even if you think you can bust your way out of this, which we see a lot with data centre type businesses or contact centre type businesses where they get a slap on the wrist from the ICO and they think, I'll bust the company and start a new one. The fine follows the director. It's part of director liabilities. So you have to watch for this because that huge fine could just stay with you forever. Equally, there are certain aspects of the GDPR that give rise to criminal sanctions. Who here does that really nice but slightly charitable thing of giving away a laptop at end of life to the local school, scouts, cubs, whatever? Yeah, there's a few nods. We've all done it. We've all got rid of those. If you're like me, the end of life with my mobile phone, it goes in my kitchen drawer. Then if somebody says, have you got a spare phone, I might give it away. Well, now that would be a criminal offence, right? Unless I can show that that's been zeroed correctly by an ISO 27001 certified authority. So you can't just delete the content. You have to contract with someone you know is doing it properly. And if you don't, and you knowingly dispose of that item, that's a criminal offence. Jail time. All right for me with my looks, but for some of you, you don't want to be going to jail. Okay, so the fines then. Let's start on the right, admin fines. It's up to 10 million euros or 2% of global turnover for certain categories of non-compliance. Let's just say they're the more tame ones. I have lists of these if you want them. There is a list of about 30 items that these would typically apply to. So for example, not seeking consent to store the data relating to a child. Be a 10 million euro fine. It's cheap. Yeah, go out, store the data of 10 children. Have a 100 million fine. And 20 million euros or 4% for the higher end, more toxic type behavior. But let's work our way back from the left now. So what are the powers of the ICO? Well, they could be investigative and they can come in, they can force access to your environment, your business, your home. They can chase that data down wherever they think it is. And they can force you through that investigation to disclose how you've processed that data, hook, line and sinker. So you just cannot get away with trying to do something that's vaguely shonky on the side or sending data outside of the EU. Then they have these corrective action powers in the middle here. Now you might get a corrective action notice first time around. If you're doing the right things, you might get a slap on the wrist and told, sort it. Great. Second time round, you might get a slap on the wrist, told to sort it and get a fine. And you might be really lucky in that might be a modest fine. And you pay it and off you go. Frankly, if any of you then get to a situation where it's third time round, it serves you right. You've been told twice, sort it. Because they'll tell you what to sort. And the ICO will really work hard to help you understand what the issues are, what the challenges are, and how best to try and bridge those. So you will get help with this. But do think on some of these corrective actions here that they can do. They're quite messy. Some of these will stop your business in its tracks. Even if an investigation doesn't, some of these corrective actions in the middle will. So if they knock on your door and you've done nothing about GDPR, and they say, right, okay, we've had a complaint, we want you to sort it, you might find yourself actually shutting shop for a month or two while you sort it all out. And I don't think anybody wants that. Okay, key considerations for the fines. This is more as an aid memoir. Have a look at this afterwards. But the ICO is not going to try and get a 20 million euro fine in place with each and every occurrence. They're not. They're pragmatists. They will look at proportionality. They will look at certain drivers of your behavior and whether or not you are doing the right thing or whether or not you are basically just ignoring all of this and hoping it will go away. And if you're ignoring it and you've got your head in the sand, you'll get a fine, and it'll be a big fine. If you're not and you're entering into the spirit of it, you'll be fine. Have a look at these points later on in your own time. They will give you a firm steer. And if in doubt, find somebody who labels themselves as a DPO. All I will say, in the interest of speed here, you've got to think about DPOs quite carefully. Not everyone needs one. This is a myth. A lot of people have been told they've got to have one. Be cautious here, because if you volunteer that you've got a DPO, you'll be held responsible for doing the things that a DPO would be expected to do in the level of rigor that a DPO would do them in. So just be cautious about this. I doubt that many of you will fall into these categories, but certain things that you have to be alert to are that the ICO has already provided opinion that, for example, certain insurance companies will automatically require one because they're processing large volumes of EU data, personal data. So there are some good guidance notes on the ICO's website that give you a firm steer as to whether or not you're likely to need one. You don't have to have an in-house one. You can outsource it. You can buy that in as a service. You've got a lot of choices around all of this. But remember, if you get a DPO, they've got to be materially supportive of your efforts around GDPR. Not someone that you're paying a truckload of cash to who's basically going to sit there in a glass box with a sign on it saying, in case of emergency, break glass. Try and get them to actually help you with your process of implementation and to make ready the organisation by providing training and awareness to the workforce and also understanding where your gaps are in the business. Finally, at the bottom here, make sure they are a true expert. It's really interesting. One of the businesses I work quite closely with specialises in big data, insight and analytics. And they've seen a lot of people come through as resprayed data engineers in some way, shape or form, then have DPOs. Great. Read a book, I'm a DPO. Now those types of people might well know a lot of this, but this is a little bit like first aid. A little bit of knowledge here can be quite harmful. Okay, so the do now checklist. There's a set of questions on here. Answer these questions. Take them away, answer these questions. If you think you can sensibly answer all of these without doing any more work, without delving further into your own venture, your own business, then you're probably going to be okay. And I'll just signpost one or two on here. Let's pick some of the obvious ones. Have we mapped our personal data inventory? It's part of your audit. You can't do a risk assessment if you don't know what data you're capturing or where it is. At the ICO, the first thing they'll be looking for is whether or not you have this inventory, this audit of data. What personal data are you capturing? How are you storing it? Where are you sending it? Who's processing it on your behalf? Have we undertaken a data protection impact assessment around this? In other words, have we looked at the risk we're exposing our data subjects to? Let's pick a couple of others out on here. Do we need a DPO? And if not, you're legally required to justify your decision not to have one. So you just write it down. It's got to be reasoned. Again, it's back to that wonderful word, reasoned. But what is your reason for not having one? Why do you think you don't need one? It's not difficult. You just need to document it and build that audit trail up. Are we adequately insured? There's a couple of interesting ones on here. Adequately insured. I'm not sure about this adequate statement, because one of the areas that hasn't yet been tested is whether or not you're likely to end up with a 20 million euro fine if you really are bad, or whether you're likely to end up with a 20 million euro fine multiplied by 10 because you have 10 quick succession breaches that all add up. So think about your insurance carefully, think about the style of business you're in and what you do with data. Could be quite problematic. And then your do now activities. Again, take this away. There are 10 items on here. Don't panic. This isn't anything to panic about. Keep calm and just get on with it. Complete a readiness assessment, a gap study, if you like, a gap assessment of where you're at. Think about your personal data inventory, map it, do it in Excel, just some columns. We refer to these as the W questions. And again, the ICO's got loads of guidance on this. They've got no templates, unfortunately, but they have got lots of guidance on this. Then do your third-party audit, your assessment of where data is flowing out of the organisation. Think about whether you need a DPO and then document your decision. Prioritise the risks that you face and start working on those. Speak to experts. There's loads of people really collaborative about this. Online forums. If you're in an industry group, if you come back to places like the IoD, ask the IoD, they'll act on your behalf. They'll find people who can answer those questions and try and get some of the answers for you. And that can be very helpful. No one's shy about giving an opinion, but you don't want an opinion. You want something that's going to be materially useful to you to get on and solve the problem of you being compliant yourself. Create your action plan. Now, you need an action plan. This is a bit like when you did your driving test. If you're like me, I did it so long ago that we used to drive along down the road, and whenever we looked in the rearview mirror, we did this, so that we could be seen to be looking in the rearview mirror. Your action plan is the rearview mirror. I don't look in the rearview mirror that way anymore. I glance at it, like we all do. But if I've got my action plan setting out what I thought I was going to do, when I was going to do it, and what the key distribution of those activities were, then I can be in a strong position if the ICO do come knocking. Explore tools. There are a lot of free tools available. A lot of e-discovery tools are available to help you with things like subject access requests. Some of them are bolted into things like Office 365, so you can go in and you can search for a data subject's name. It will find every occurrence within that part of the enterprise, just to make it a bit easier. If you've got boxes of paper data, you might need to do a bit more work around that. Think about data minimization, come up with a list of what you don't need and get rid, and then think carefully about implementing new policies, training the staff, putting in place a process, and then doing your contract changes to protect you through your relationship with third parties, where you're either part of their supply chain or they're part of yours. And then finally on here, make sure your staff are up to speed on this, and then telegraph the message to your customers. This is a clear differentiator, a very clear differentiator. If you're like me, I'd rather do business with someone I thought was open, honest, and had great integrity about what they're doing with my data. If I think it's going into a black hole somewhere and it's going through a rinse and repeat cycle, I'm not happy. Thank you all very much.